Hey, just dropping in to say we're now on Patreon. If you want to support the project, head on over to patreon.com/legalistening, where you can unlock some fun bonus content with me, Zach, and some special guests. Thanks so much for all your support. Hey, welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today.
Hi there, welcome to Legal Listening, where audio obiter is our thing. I'm Zach, and today I'm going to be taking you through an Ontario Court of Appeal decision, the Queen and Braithwaite. Before I get into this case, I would like to mention a content warning for this particular case, as it deals with sexual harassment and stalking. Viewer discretion is advised. The Ontario Court of Appeal between the Queen and Scott Braithwaite. On appeal from the convictions entered on August 26, 2019 by Justice Richard Ledresse of the Ontario Court of Justice. Reasons for decision. The appellant was convicted of breaking and entering, voyeurism, and criminal harassment of the complainant, with whom he had an intimate relationship. The complainant ended the relationship after 2 years, and the appellant did not take the breakup well. The appellant sent the complainant so many emails and text messages that in November 2016, the complainant went to the police to complain about the unwanted contact. Thereafter, she began to receive emails and text messages from unknown addresses that she believed originated from the appellant. Around this time, in November of 2016, the complainant discovered that the passwords to both her Apple ID and her Facebook page had been changed. She also received a notification that her Apple ID had been used to log on to a new device. She testified that in November and December, she noted many times on returning home that her garage light was on or her door was not locked. Additionally, someone set up fake and derogatory dating profiles in the complainant's name on a dating website. Derogatory email and text messages about the complainant were sent to her employer. In January of 2017, the principal of the complainant's children's school was sent photos of the complainant, along with allegations of misbehavior on her part. On December 28th, the complainant awoke to find her cell phone on the floor rather than the bedside table where she had left it. The passcode had been changed. She found her front door unlocked and a key left on the table. She concluded that someone had been in her home while she was asleep. 2 days later, she noticed a Ring camera on the floor in her bedroom, pointed at her bed. The police arrested the appellant and searched his cell phone, incidental to arrest. A forensic search of the cell phone and his computer revealed several images that almost certainly originated from within the complainant's residence. Some of the images were of documents kept in the complainant's wallet, such as credit cards and a business card she had received from the Halton Regional Police Service after making a complaint about the appellant. One image was of the complainant's cordless phone, apparently displaying a call incoming at 12:01 a.m. on November 22nd. The time displayed on the phone matches the time and date of the image of the phone found on the appellant's cell phone. The cell phone and computer extractions also revealed nude photographs of the complainant taken in her bedroom. Both the angle of the photographs and the Ring watermark suggest that they were taken from the Ring camera the complainant discovered on her bedroom floor. The complainant testified that she had never shared nude photos of herself with the appellant. The extraction report also showed that on December 28, 2016, the day which the complainant claimed someone had entered her residence and changed the passcode on her cell phone, the appellant's cell phone received a notification that the complainant's cell phone was now sharing its location with the appellant. Also located on the appellant's cell phone were notes that the appellant had written recording his feelings about the complainant and the breakup, complaining of her treatment of him and wondering, "Is this some kind of sick game? Are you okay? Who treats people like this? Who can be so morally corrupt and still not think that they've done anything wrong?" The appellant was convicted of criminal harassment, voyeurism for a sexual purpose, and 2 counts of break and enter. He was sentenced to 12 months custody, less 6 months credit for pre-sentence custody and time spent on restrictive bail. Analysis. The appellant advanced 3 grounds of appeal against conviction. 1. The trial judge erred in finding that the appellant had animus towards the complainant, and this animus supported a finding that the appellant was the person who committed the acts of criminal harassment. 2. The trial judge failed to make a finding that the complainant was fearful of the appellant, which is a necessary element of criminal harassment. And 3. The trial judge erred by convicting the appellant on circumstantial evidence when the evidence was open to reasonable inferences other than the appellant's guilt. See the Queen in Villa Roman. With respect to the argument concerning animus, there is ample evidence from which the trial judge was able to draw the inference that the appellant had animus towards the complainant. In particular, the notes that were recovered from his device did not simply record his sorrow and self-pity. Some, at least, were directed at the complainant and were accusatory in nature, suggesting not only that he was the victim of her unjust treatment, but that she was both morally and psychologically disordered. With respect to the second ground of appeal, it is true that the trial judge did not make an explicit finding that the complainant was fearful of the appellant. She may not have been fearful during the initial period in which the appellant was continually messaging her. However, the record clearly establishes that she was fearful after discovering the Ring camera. The words she used to describe her reaction were shocked, petrified, anxious, upset, and violated. This was before she learned of the nude photographs of herself on the appellant's devices. Finally, the appellant argued that as the evidence was circumstantial in nature and there was other explanations for the evidence equally consistent with the guilt of the appellant, he ought to have been acquitted. In his oral submissions, he pressed that it was much more likely that the complainant had fabricated the evidence, including the apparent surreptitious nude photographs in the bedroom that was downloaded to his devices without his knowledge. We do not agree that the trial judge made an error. The circumstantial evidence against the appellant was overwhelming. Neither was there an evidentiary gap that could have left for the trial judge with a reasonable doubt. In these circumstances, it was open to the trial judge to conclude that the only reasonable inference available was the appellant's guilt. The appellant's strongest argument on the evidence is that some of the images found on his devices predated the two specific dates of the two counts of the break and enter for which he was convicted. There is nothing to this. The information covers a period of time from October 1, 2016 for the voyeurism offenses and November 2, 2016 for other offenses. They are not tied to the dates particularized for the two counts of breaking and entering. The two counts of breaking and entering do not preclude the drawing of the inference that the appellant had been unlawfully present in the complainant's residence on other occasions, which inference is also supported by the evidence at trial. Disposition. The appeal is dismissed. Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.